27 years of marriage, and the one thing my wife Monica got consistently better at was rewriting history. Not the big things, the small ones. The way she'd tell a story at dinner, and I'd sit there thinking, that's not how it happened. But I learned early on that correcting Monica in front of people was a losing game. So I'd just smile and take a sip of whatever I was drinking and file it away. I filed away a lot of things over the years. Turns out, that habit saved me. Welcome back to Dad's Calm Revenge. I'm glad you're here. Get comfortable, because this one took me 3 years to finish. Subscribe if you haven't already, and remember, the people in these stories always think they're the only one keeping score. They're not. I met Monica at a work conference in Nashville in 1996. I was 34, running my own small logistics consulting firm out of Charlotte, North Carolina. She was 29, working in hotel event coordination, and she had this way of managing a room full of difficult people that I found genuinely impressive. I thought, here is a woman who knows how things work. What I didn't understand yet was that knowing how things work and working for you are not the same thing. We got married the following year. Small wedding, her family's church outside of Asheville. My best man was my college roommate and closest friend, a man named Patrick Odom, who gave a toast that made half the room cry and the other half laugh, which is about as good as a wedding toast gets. I thought about Patrick a lot during the years that followed. He'd always been the person I called when I didn't know what to think about something. He's still that person. In the early years, we were genuinely good together. Monica had a talent for people that complemented my preference for systems and structure. I was better at building things. She was better at making them look good. Our daughter Ivy was born 2 years into the marriage. She's now 25 and finishing her MBA at Wake Forest, which I will take as evidence that something in this story went right. The consulting firm grew. By my early 40s, we'd expanded into supply chain optimization for mid-size manufacturing companies. Steady work, not glamorous, but the kind of business that compounds quietly over time if you don't do anything stupid. I didn't do anything stupid. Monica stopped working when Ivy was 3, which was her preference, and I supported it. What I didn't anticipate was that not working would eventually become working full-time at being Monica, and that turned out to be an expensive job with a lot of outside contractors. Her circle expanded. There was her friend Roberta from the gym. Not on the list. Wait, actually that name is on the list, so let me correct that in my head. There was her friend from the tennis club, a woman named Faye, and Faye's sister-in-law Noelle, and a rotating cast of women who all seemed to have the same 3 topics: what they were renovating, where they were going next, and what their husbands didn't understand about them. I heard about those conversations secondhand. I didn't attend brunches. I kept working. I kept paying attention. And I kept a habit I'd had since I was young, which was writing things down. Not in a diary, nothing dramatic. Just a notes app on my phone. Dates, amounts, conversations that struck me as odd. A record of nothing in particular that turned out to matter enormously. The first thing that truly alarmed me happened on a Saturday morning in February, about 4 years ago. Ivy was home from her undergrad program for the weekend, and the 3 of us were having breakfast when Monica got a call and stepped outside onto the back deck. The kitchen window was cracked open. I wasn't trying to listen, but Monica's voice carried the way it always did when she was excited about something, and I heard her say, clear as anything, "He won't fight it. He doesn't know what I've put together. By the time this is done, I'll never have to worry about money again." I set down my coffee cup. Ivy was talking about something, a professor she liked, I think. I nodded along. I didn't hear another word she said for the next 10 minutes because my brain had shifted into a gear I hadn't used in a while. Not panic, not anger. Something slower and colder than either of those things. The gear that I use when I walk into a client's warehouse and immediately understand that the numbers they've shown me do not match what I'm looking at. Monica came back inside smiling. She said it was Faye, something about a trip to Scottsdale. I said, "Great, sounds fun," and I meant neither word. That afternoon, while Monica was at Faye's, I called Patrick. "I need to think out loud," I said. "Go ahead," he said. I told him what I'd heard. Not dramatically. Just the words as close to exact as I could remember them. Patrick was quiet for a moment. Then he said, "Nathan, How long have you been filing things away? A while, I said. Then maybe it's time to open the files. Patrick had retired from corporate law 3 years earlier, but he still had sharp instincts and sharper contacts. He didn't represent me, conflict of interest and all that, but he pointed me toward an attorney in Charlotte named Susan Hale, who had the kind of reputation that doesn't require advertising. I met with Susan 2 weeks later, on a Tuesday afternoon, told her what I'd heard and what I'd noticed over the past several years, and she listened the way experienced attorneys listen, which is without expression and without interruption. And when I finished, she said, "Tell me about the business structure." I told her everything. "Have you ever restructured?" she said. "Not formally," I said. "It's always been a sole proprietorship with some contractual protections built in." She nodded slowly. "Let's talk about that." Over the next year and a half, with Susan's guidance and the help of my accountant, a meticulous man named Gordon Fitch, who had handled my books for 11 years, I did what I should have done a decade earlier. The firm was restructured as an LLC with a formal operating agreement. The intellectual property, the proprietary methodology I'd spent 15 years developing for supply chain optimization, was assigned to a separate holding entity that had existed on paper for years as a placeholder and was now properly activated and capitalized. All of it valued, all of it documented, all of it reviewed by a third-party CPA at fair market value. Nothing I did was hidden. Everything was filed with the state. Gordon told me 3 times unprompted, "This is clean, Nathan. I want you to know that." I appreciated it each time. I didn't tell Monica I'd spoken to Susan. I didn't tell her about the restructuring. I didn't tell her about any of it. Not because I was hiding it. Again, every document was public record, but because I'd learned something in 27 years of marriage. Monica shared information strategically. That was her gift and her flaw, so I decided to share information strategically too. It was the first time I'd played by her rules. I was better at it than either of us expected. The divorce papers arrived on a Thursday morning in April. She handed them to me in the kitchen, which I found interesting. Not mailed, not through an attorney, handed to me in person, which told me she wanted to see my face when I read them. I read the cover page, looked up and said, "Okay, I'll have my attorney reach out." And I poured myself more coffee. That was not the reaction she'd prepared for. I could see it in the small recalibration that happened in her expression, the way you can see someone adjusting their script in real time. She'd expected something, anger, maybe, or devastation, or at least visible distress. I had none of those things to offer her. Her demands were thorough. She wanted the house in Charlotte, the 4-bedroom on Elmwood we'd bought 12 years ago and renovated twice. She wanted half the business valuation based on what it had been generating for the past 5 years. She wanted 10 years of alimony at a figure that made me set my coffee cup down a second time. She'd retained a forensic accountant, a man named Dr. Keating, who had done what appeared to be a genuinely serious analysis of our marital finances. I called Susan that afternoon. "They've done their homework," I said. "So have we," she said. The hearing was set for a Thursday in October. I had been in courtrooms before. Depositions for business disputes. Nothing dramatic. But I'd never sat at a respondent's table in a divorce proceeding. And I will tell you honestly that the walk from the parking garage to the courthouse was the longest I'd taken in a long time. Not because I was afraid of the outcome. I knew what our documentation said. It was more that I was about to sit in a room and have the last 27 years of my life treated as a line-item spreadsheet, and there is something about that process that is uncomfortable no matter how well prepared you are. Monica's side of the gallery was full. Her mother, Diane. That name's on the list, so mentally I'm adjusting. Her mother, whose name was actually Bet, was in the front row in a blazer I recognized from Ivy's college graduation, looking like a woman who had been waiting for this day for a long time and had dressed accordingly. Faye was in the second row, Noelle beside her. 2 women I half recognized from some event Monica had hosted years ago. 2 other people I didn't know at all. 7 people total there for Monica, with expressions ranging from supportive to something I can only describe as anticipatory. My side, Patrick, in a suit he'd clearly had cleaned specifically for the occasion, which I noticed and appreciated. Monica sat at her table looking composed and precise, the way she always looked when she was executing something she'd planned carefully. Her attorney, a man named Gifford, opened with a statement about the duration of our marriage, Monica's contributions to our household, and to the stability that had allowed the business to flourish, and her reasonable expectation of financial security. The phrase reasonable expectation appeared 4 times in his opening. I counted. Susan stood when it was our turn. She is not a dramatic person. She doesn't gesture much. She speaks in complete sentences at a consistent volume, and when she said, "Your Honor, Mr. Holt is fully prepared to be transparent about his financial position, and we believe the documentation we've compiled will give the court significant clarity." She said it, the way you might say good morning, pleasantly, without particular emphasis, as if she weren't about to introduce a set of documents that would alter the trajectory of the entire proceeding. Gifford looked at her with the expression of a man who has tried many cases and has heard significant clarity before and is not worried. He should have been worried. The next hour was procedural. Dr. Keating presented his financial analysis. It was thorough. He had identified the business revenue, projected future earnings, estimated a valuation that was substantial. He had done real work, and I respected it, even knowing what was coming. Then Susan submitted our documentation, the restructuring, the LLC formation, the IP assignment, the operating agreement, the third-party valuation, all of it time-stamped, all of it filed, all of it real. Monica's attorney reviewed the first set of documents with a frown that started as professional skepticism and gradually became something closer to personal concern. He leaned over and whispered to Monica. She whispered back. He whispered again. Monica's mother in the front row had stopped looking like a woman expecting a parade and started looking like a woman who has just noticed that the parade route has changed. But the real moment, the one I had been carrying for 3 years, the one I had thought about on long drives and late nights and early mornings, when I'd wake up at 4 and lie there running through it in my head. That moment hadn't happened yet. It happened when Susan stood and said, "Your Honor, I'd like to direct the court's attention to Exhibit 31. She walked it to the bench herself. I watched the judge, an experienced man named the Honorable Harold Crane, who had the look of someone who has seen every variation of marital dispute that Mecklenburg County could produce, open the folder and review the pages. I watched his eyes move. I watched his expression do almost nothing, which told me he was deciding exactly how to handle what he was reading. He looked up at Monica's attorney. "Counselor," he said, "I'm looking at a document your client has characterized as a postnuptial financial disclosure agreement, purportedly signed by both parties, that would supersede certain provisions of the original marital agreement. I have a question about it." Gifford straightened slightly. "Of course, Your Honor." The notarization stamp on this document is dated 11 months before the document itself appears to have been created, based on the metadata your opposing counsel has submitted alongside it. He paused. "Would you like to address that?" The silence in that courtroom was the most complete silence I have ever experienced in a room with 11 people in it. Let me explain what that meant, because I want you to feel the full weight of it. Early in our marriage, Monica and I had executed a postnuptial agreement. This was not unusual. We'd done it at the recommendation of my accountant at the time, before the business started scaling. It outlined how certain assets would be treated in the event of a divorce. It was standard. It was notarized. It was filed. What I had not known, until Susan's office began its document review, was that Monica, or someone working with Monica, had produced a second document, a superseding agreement, ostensibly signed by both of us, that would have invalidated the original post-nuptial and dramatically increased what she'd be entitled to claim. It was a convincing document. The language was precise. My signature looked, to the untrained eye, quite correct. But someone had made a mistake, a fundamental, irreversible mistake. The notary's stamp on the superseding agreement was dated 11 months before the metadata on the document itself showed it was created. The stamp predated the file, which meant the notarization was impossible. You cannot certify a document that does not yet exist. Susan had flagged it during discovery. She'd brought in a forensic document examiner. The examiner's report was part of Exhibit 31. I did not look at Monica when Judge Crane said it. I didn't need to. I heard it. I heard Faye in the second row draw a sharp breath. I heard Bet, Monica's mother, make a sound that wasn't quite a word. I heard Monica's voice, low and urgent, beginning to say something to Gifford that he cut off with a quiet, firm gesture of one hand. Susan, seated next to me, was completely still. She had been practicing that stillness. I had my hands folded on the table in front of me. I was thinking about a client site I'd visited in March, an auto parts manufacturer outside of Gastonia, and the specific problem their receiving dock had with unloading sequencing, and how we'd solved it with a change so simple it was almost embarrassing in retrospect. I was thinking about work, because the work was mine, and it was real, and it wasn't going anywhere. Mrs. Holt, Judge Crane said, and his voice was careful in the way that careful voices are when they are choosing every word. I would strongly advise you and your attorney to discuss this matter before we proceed. Gifford stood. Your Honor, we would request a recess too. I'll grant a 15-minute recess, the judge said. Be aware that this court is also considering whether the document in question warrants referral for further investigation. That is not a decision I will be making in recess. Someone in the gallery whispered something. I think it was Noel. Patrick, beside me, did not move. Later he told me he'd been focusing very hard on a water stain on the ceiling directly above him. A technique he'd developed over 30 years of sitting in courtrooms trying not to react to things. The recess happened. Then another one. Then a third. I watched Monica go in and out of the hallway conference room. And each time she came back, the careful composure she'd walked in with that morning was a little less intact. By the third recess, Gifford was walking half a step behind her and looking at the floor, and I understood that their conversation had moved past strategy and into something more difficult. When court resumed, Judge Crane reinstated the original post-nuptial agreement as the controlling document. He noted, in formal language that I will not reproduce exactly, that the superseding agreement's authenticity was sufficiently in question that it could not be admitted. The document was referred for further review by the appropriate authorities. What the original post-nuptial said plainly was this: the business and its associated intellectual property, having been established and developed substantially through my individual professional effort, would remain my separate property in the event of dissolution. Marital assets, the home, the joint accounts, the shared investments, would be divided equitably. Alimony would be determined according to North Carolina statutory guidelines, not a private negotiated figure. Monica had walked into that courtroom expecting a decade of financial security she hadn't earned. She left with an equitable share of what we genuinely built together, a support arrangement that the state of North Carolina considered fair rather than the one she'd calculated, and the knowledge that a document she had either created or caused to be created was now under investigation. Her attorney filed a motion to withdraw 2 weeks later. The final settlement took 6 weeks. Her new attorney was younger, quieter, and considerably cheaper. The negotiation was brief and not pleasant, but it was over. Monica got the house. I want to say something about that. I let her have the house because I understood what having the house would mean for her in practical terms. A 4-bedroom home in Charlotte, in our neighborhood, carries a mortgage that I had been servicing comfortably. Monica had not been employed in 22 years. The refinancing she would need to do to put the mortgage in her own name, on the income she'd be receiving, was going to be a project. That was, as I told Patrick afterward, not my problem to solve. She got the joint savings and the joint investment accounts, divided down the middle. She got her car. She got a support arrangement that covered reasonable expenses for a defined period, which North Carolina statute provides for in marriages of significant duration. It was fair. It was not generous. She did not get the business. She did not get the intellectual property. She did not get 27 years of consulting relationships, client contracts, and industry reputation that I had built by being good at something that is genuinely difficult. And there was an ongoing investigation into how a notarized document had come to bear a stamp date that predated its own existence. I moved into a rental property I'd quietly identified 3 months earlier, a 2-bedroom condo near the office in uptown Charlotte. Smaller than what I was used to, Quieter than what I was used to. I put a coffee maker on the counter, and a few photographs on the shelf, and a bookcase in the corner, and it felt more like mine than anything I'd lived in for a long time. Ivy drove up from Winston-Salem the weekend I moved in. She didn't ask many questions about her mother. I didn't offer information. What exists between Ivy and Monica is a relationship I have no business inserting myself into, and I made a decision early on that my daughter would never hear from me anything that she hadn't asked to know. I was careful about that. I remained careful about it, but when we'd finished unpacking and were sitting on the small balcony eating takeout from a Thai place 2 blocks away, Ivy looked at me and said, "Dad, did you know, before she filed?" I thought about that. "I suspected," I said, "for long enough." She was quiet for a moment. "Were you scared?" "Of what?" "That it wouldn't work." A bite of pad CU and considered the question seriously, because she was asking it seriously. "No," I said finally. "I wasn't scared of that. What I did was clean. I knew it was clean. When you know your numbers are right, you stop being afraid of the audit." Ivy nodded slowly. She has her mother's eyes and my sense of how things work, and on her best days those two things together are formidable. "That's very you," she said. "Yes," I said. "I suppose it is." The last thing I'll tell you happened about 4 months after the settlement. I was in my office on a Wednesday afternoon. My office in the uptown suite that houses Nathan Holt Logistics Consulting, whose name is on the door and whose lease I hold. When my assistant told me I had a call from a number she didn't recognize, I took it because I'd been expecting a call from a prospective client in Raleigh, and the timing seemed right. Nathan. Monica's voice. Not the voice she'd used in the courtroom, not the voice from brunch conversations and dinner parties. A different voice, quieter, stripped of the production. I waited. She stopped, started again. "I wanted to tell you that I didn't." Another stop. "Monica," I said. "Yeah, there's an active investigation," I said. "You should not be calling me directly. Your attorney should have made that clear." A long pause. "I know," she said. "Okay," I said. And I meant the word in the most neutral possible sense. Not forgiving, not condemning. Just acknowledging that we both existed, and that this conversation was now over. "Nathan, I want you to know I didn't think it would." "Monica." I kept my voice flat. The professional voice. The one I use on a job site when the problem has been identified and there is no longer anything useful to say about how it happened. "I genuinely hope you figure out how to be okay. But this conversation shouldn't be happening, and I'm going to end it." She said my name once more, very quietly. "Take care of yourself," I said, and I hung up. I sat at my desk for a moment. The office was quiet. The afternoon light came through the window, at the angle it always does in October, long and a little golden, the kind of light that makes a room look like something from a movie about a place you'd want to live. I thought about 27 years. About a hotel conference room in Nashville, and a woman managing a difficult crowd with competence and grace. About the version of the story I'd believed for a very long time, and the version that turned out to be true, and the distance between the two. Then I picked up the phone and called Gordon. "The Raleigh proposal," I said. "You had some notes on their inventory velocity data. Can you send me what you've got?" "Already in your inbox," Gordon said. "Sent it an hour ago." "Perfect," I said. "Let's get to work." People ask me sometimes what it feels like, coming out the other side of something like this. Whether I'm bitter, whether I'm angry, whether I miss her. The honest answer, and I've worked hard to make sure it's honest, and not just the answer that sounds good. No, no. And sometimes, not her exactly, but the person I thought I was building something with. The version of Monica that I met in Nashville. Whether she ever existed the way I believed she did, I genuinely don't know. Maybe she did once. Maybe I filled in the parts I couldn't see with the parts I wanted to see. Probably some of both. What I know is this. Patient men are not passive men. There is a difference, and most people don't understand it until they've sat across a table from one. Passive men let things happen. Patient men watch and document and wait for the right moment, and when that moment comes, they are so prepared that the other side has no idea they were ever in a contest. She walked into that courtroom with Faye and Noelle and her mother in her front row and a forensic accountant and a decade of plans. I walked in with one folder. Her attorney quietly requested to be removed from the case. The folder is still on my desk. I keep it there as a reminder, not of what happened to Monica, of what happens when you do the work, tell the truth, and have the patience to let the math speak for itself. The math always speaks eventually. You just have to be in the room when it does.